Well, this is the meeting of the Discipline Subcommittee of the California Paraprofessional Program Working Group. I'd like to take the roll. Bashan, I don't think she's here yet. Falmouth?
Here.
Kirkmeyer?
Here.
Spiro?
Here.
Okay, thank you.
All right, so let's see if we have any. We have one attendee. Do the attendee want to make public comment? If so, raise your hand.
I don't see anything. Yeah.
All right, so I think today we said we were going to focus on public records. Is that right? Ira, Kim, yeah. Okay, so I put the chart up. Where do you all want to start? We decided in our last meeting that this is going to be NA on the ALDs. I don't think we discussed warning letters. I'm assuming we're still going to have warning letters. And this would be private.
I would agree with those being private. There's no violation.
Yeah, me too.
Or not one that can be proven anyway.
Kim, do you want to explain the citation and fine just verbally how it works?
Yeah, definitely. So this did change a little bit for us. It used to be that as soon as they were issued, they were public, but it got changed to where you issue the citation and then it becomes public 30 days after issuance. But if there is an appeal that comes in, and that appeal could either be for an informal conference with the staff, or it could be an appeal to administrative law judge for a hearing, either one of those appeals, then it doesn't become public until there is an outcome on that appeal. So then once that outcome is, let's say that it gets upheld, then that becomes public, and then it's available for 3 years from basically either the date it's resolved by a payment. So if it's just a citation and fine, and that fine is, $500, they pay their $500, and then it's on their website for 3 years. And then if it is, you had an order of abatement, it's 3 years from whenever they met that order of abatement. So I know, Leah, you had asked like the difference, like sometimes there's fines attached and sometimes there aren't. We do some citations where it is only an order of abatement. So for example, a failure, and actually it's not even an order of abatement if they've already provided it, but we will issue a citation for failing to notify a board within 30 days that they've moved. And then we find out and we issue them a citation. We don't put a money amount on it, but we just issue the citation. And then they just provide us their new address, and then it's abated, and then it's 3 years from there.
Okay.
And then for citations, though, citations are one where they don't go on publicly. So it's actually 3 years and they're gone completely from the record. They're purged from the record. Unlike some of the other limitations, time limitations, they have a time, but it's in the file at the board, but it's available indefinitely. Citation is not like that. It's actually purged completely.
Okay, so it's in this category, public finite term.
Yes.
Okay.
I'm sorry to, I just realized something. There's at least 3 things I think that could be designated and how we're treating these things. There's whether it's public in the sense of being available to the public if they look for it. There's whether it gets listed, not listed, noted, flagged on the web page of the paraprofessionals. And third, how long it stays in the records of the agency, whatever the agency is, whether it's public or not.
Yeah, I think if you look at the screen, this is how I tried to organize it. So public upon request, public on the website, public in perpetuity. And these are not all mutually exclusive. Public finite term. And then private, I just annotated this in perpetuity, private finite term. So that even if it was private, you might destroy the record at some point.
Oh, so finite term there means finite term for the record even existing, right?
Yeah. Like for example, in the discipline system on this, we did a study on racial disparity in our discipline system. And one of the recommendations was a complaint where there's been no subsequent complaint received and the complaint was not substantiated, to totally destroy it after 5 years. So the complaints themselves are not public, they're already private, but then to destroy it. So that's private finite term.
Yeah, and our boards have those as well. Otherwise, they'd have them, complaints forever. And so it depends on the board. Like at medical board for a while, we had, if it was closed, no violation, we'd purge it after 1 year from the closure date. And if it was closed, basically insufficient evidence, we would purge it after 5 years. But right before I left, I know they were working on that because for medical board, they have a statute of limitations of 3 years. So they were working on maybe changing that 5 years to a lower number of years. But for complaints, that's how it is for them too. And most boards are like that.
Up in options for public, Leon, your list there at the bottom, options for public records. Now, where it says public in perpetuity, don't we need to say whether that means it's public forever or that means it's in the records forever and never gets destroyed?
Well, in perpetuity to me means it's forever and it never gets destroyed. So maybe this nomenclature is confusing, but that I meant by public and perpetuity, I meant public, it's public A. This probably isn't a great list because these are kind of discrete categories, but A is public. It would be like this. Is it public or private? Yes or no. So let's say it's public. Is it available upon request or is it affirmatively posted on the website? Yes or no. That's the next triage question. Is it a record that will be maintained forever or does it have a finite term? So for each record, we go public, private, website, or on request for the public stuff. Lasts forever, has a finite term.
I think it needs another category or question.
Okay.
How long does it remain public, even if it's, can it become non-public but still exist as a record?
Okay. Does that happen in the medical world, Kim?
So can you explain that to me?
I think there's a difference between public disclosure and public in terms of the Public Records Act. So, and that's maybe another distinction we should draw here, because even if some stuff on the medical board's website comes down after 3 or 5 years, but if somebody does a Public Records Act request for it, I think they can get it unless it's been purged. And Kim, is there some separate statutory authority for that purging?
It's a reg.
Does the reg limit how long it has to be remain in existence, the record?
Yeah, it does for citations, and it's not for everything. So there's some documents, just like Julie was saying, some of them are based on public, and some of it's based on like what the board uses them for. So things that are public, those have specific statutes and regulations that say how long they are or aren't public. But then like the complaints, because those would never be out either at you couldn't get those from a Public Records Act or from statute or anything, or I mean, yeah, from a Public Records Act request. Those are more policy then, so then we put those into a records retention schedule, if that makes sense. So those are on a something different than when we're talking about actual documents that are based on outcomes of either citations or discipline on a doctor. And it could also change between, like, it could be public upon request for a certain amount of time, but it could also be public on the website for a certain amount of time as well.
Is this what you're getting at, Iris? Okay, so let's say question one is it public or private? Then we say, if it's public, is it public on request or on the website, which I would call like affirmative or responsive. If public and on the website, does it transition from public affirmative to public responsive? Like, does it transition from being put on the website to made only available upon request? Like, for 3 years, we put the fine on the website. Then after that, it's still public, but you have to ask for the information. We don't publish it.
When you say on the website, you mean on the professionals page?
Yeah.
Yeah, there's some, for at least for us, that could happen. Like, it goes on to the website for, like, the cite and fine, it goes onto the website for 3 years, and then it comes off. And unlike a public letter of reprimand that stays indefinitely, it gets purged completely from the file. And I think that regulation, Julie, I think it's 1364.15, if I remember right. It's been a while, but I think that's what it is. So it depends on the laws, right?
Yeah, but the statute 803.1 says that infractions, citations, or fines imposed are public record and have to be disclosed upon request. So I'm wondering how a reg can trump that statute, the reg that says after 3 years we'll purge them.
Yeah, not sure, but it made it through.
I know.
And the same thing with, like, an accusation that has been withdrawn.
Yeah.
That also is in that section where after 1 year it'd get purged too, so that you'd never be able to get a copy of it.
So to make this a little easier, why don't we start with the first question, public or private, and then go to the next level? How about we try that?
Okay.
So does everyone agree that a warning letter is private?
Yes.
Yeah.
Okay. Citation and fine, understanding that you're not always going to have these, they're not really one lumped together thing, but I'm calling them that for ease. So is it public or private?
I think it should be public.
Okay. Ira?
Well, public in the way it's stated there.
And Julie, do you think the citation and fine should be public, just as the first pass of our questions?
Yes.
Okay. So NDC, notice of disciplinary charges, I think we would say public.
Yes.
Okay.
And that's the accusation, right?
Yes.
Okay.
A private reproval. Have we confirmed that we're going to have private reprovals in the paraprofessional world?
I think so.
Sorry, Leah, just real quick, what's a private reproval again? It's like a letter, like, that is a reproval, but doesn't go out to the public.
Yeah.
And it is discipline.
Hmm.
Oh, it's discipline?
Discipline, but it doesn't, the thing with reprovals, either public or private, they are disciplined. They do not require Supreme Court action because they don't affect the attorney's license. And
They
some of
don't?
them are private and some are public.
Even though even though private reproval is, even though reproval is discipline, it does not affect the license?
Right. If it affected the license, the Supreme Court has control over attorneys' licenses. Reproval is the lowest level of formal discipline.
Hmm. What kinds of things can get or do get private reproval?
You know, I don't know off the top of my head, but they are disciplined, and part of the reason they are disciplined is that then it's considered when if there's another complaint, then that is part of the disciplinary record that can be reviewed.
Is that the one that the licensee has to stipulate to it?
No, I don't think so.
Okay, I'm
The ALD.
using med board and lawyers.
We do, yeah.
It's just it's kind of like a very stern formal finger wagging, I think, is what it is. And the other thing is, and I think that Danny talked about this, there's private and public. So, but they're both considered private. And the reason a private reproval might be public is if that's the discipline that's ultimately determined after the NDC is filed.
I can see there might be some very minor violations that ought to be, they're so minor that they ought to be private. So my opinion right now is private for the private reprovals. If they're not, we better not call them private reprovals.
And my opinion, just as you probably figured out by now, is if you're going to give discipline, I don't think it should be private.
Julie, your thoughts?
I don't know. If you have citation and fine,
Do
I
you
don't
need,
know why you need a private reproval unless you want to unless the goal is to keep it private, because the citation and fine will become public.
Hmm.
yeah, you've got the warning letter, which is not discipline and is private. You've
Right.
got citation and fine, which is discipline.
No,
No.
ours is just administrative, yeah.
It's not discipline and it's public.
Yeah.
So private reproval, it is going to be discipline, but it would be private.
Well, I'm just looking at this rule of procedure, the court's rule of procedure 5.127. Apparently it depends on whether the private reproval was imposed before the notice of disciplinary charges were filed or after. If it was imposed before charges, it seems that reproval is part of the attorney's official state bar membership records, but it will not be disclosed in response to public inquiries reported on the state bar's webpage or available to the public unless it is introduced into evidence in a subsequent disciplinary proceeding as a prior record of discipline. If it's imposed after charges, it's part of the attorney's official state bar membership records and will be disclosed in response to public inquiries and reported on the state bar's webpage.
So we kind of have something similar on the medical side. We have, but not at the same time, we have what is called a public letter of reprimand, and it's in a different code section than our normal discipline. It's in 2233, and it would be we would still negotiate it. We'd issue the public letter of reprimand. It's discipline, but it gets filed before an accusation is filed. So same thing as your NDC. So it happens the same, but those are public, but they're only public for a set amount of time. And then we have one in 2227, which is our normal discipline. And that the 2233, the public letter of reprimand, is discipline as well. And then we have one is called a public reprimand in 2227 that gets filed after an accusation, or that happens after an accusation, like after your NDC, and it is also public. So just kind of looking at how those two items are defined for the bar. We have them, but it's not a private reproval. It's still public. And maybe we've been, we've had a lot of public advocacy, and even Julie's group with CPIL in, just different things that have come to our board where we're a little bit more, and I think it's more of a DCA thing where there's not a lot of private, I don't think anybody has private discipline that I know of.
Something just occurred to me. I think what we're talking about now is whether to have private approvals and not whether they would be private or public, because they would obviously be private, right?
Well, if we were gonna have a private reproval, it would be private. Yeah, the question is, are private, although as Greg mentioned and as reflected in this chart, they're not private if they're imposed subsequent to an NDC being filed. But
They're called private anyway.
That's what, so it's always perplexed me because I don't see much of a difference between a private reproval after charges are filed and a public reproval.
It's a public.
It's a weird rule. I'm not sure.
Newsworthy.
presumably it's just another tool to resolve cases, right?
I guess what I'm saying is if it's after charges are filed, why not just call it a public reproval? Because it's made public in every way that a public approval is. So,
right. I think so.
Okay, but I do think the fundamental question is, do you want to have something called a private reproval? Which would be private, presumably, unless an NDC was filed, then it would be called a public reproval. But in some instances, I guess these are imposed without an NDC being filed.
Here's an example of something that seems to me should be a private one. For instance, somebody's the representation ends, the client says, please turn over my file. The paraprofessional turns over part of the file, but screws up and doesn't turn over all of it. The client gets angry and files a state bar complaint, and the paraprofessional realizes, oh, I made a mistake, and sends the rest of the file.
Kim or Julie?
I still have a problem with discipline being private. That's just probably more from my background.
Yeah, it just seems like there's so many categories of this stuff. And never having been a prosecutor, I don't know what the criteria are for approaching even the situation that Ira just described. If they intentionally withheld or altered client records, that would tip toward more serious sanction. If they just screwed up, I maybe even would go with a warning letter. I don't know. I don't know how to, but if it is going to be discipline, I'm with Kim, it should be public.
And just to Ira's, oh, sorry, Ira, go ahead.
My hypothetical there might have been wrong under the state bar's ethics rules, because doesn't something have to be intentional or grossly negligent? Intentional. Doesn't something have to be intentional in order to be the subject of, in order to result in discipline? Somebody else know?
No, I don't think so.
it has to be willful, but the definition of willful just means you intended the act. So,
Well, okay.
I mean, if something's intentional or grossly negligent, it may affect the charging decision as well as the level of discipline imposed, of course.
If it's plain old negligent, it sounds like it's not willful.
Yeah, I mean, there,
Well,
the state bar also uses admonitions, which are, a violation is established, but they determine there's no violations, client security fund rules. It's not a serious offense, meaning it's not involving dishonesty or moral turpitude. Doesn't appear to be intentional or occurred under mitigating circumstances, and there's no significant harm. And in those cases, the court may just issue a letter of admonition, which is not considered discipline. It's like a warning letter.
we got to have another category too.
Yeah, exactly.
Have that on the chart.
I think you can put that next to a warning letter because
Warning letter.
it's basically the same. It has the same effect as a warning letter.
You're saying the court issues an admonition
Yeah, it says state bar court may admonish an attorney.
because the warning letter is issued by OCTC.
If it's state bar court issuing an admonishment, then you already have a public record of the charges. Once charges are filed, the proceeding becomes public. So it's just not considered discipline as a final result, and it's used in the reflected.
Is that
Okay.
that's like in between a dismissal and a discipline, it sounds like.
Yeah.
Yeah, interesting. And so like with Ira's example for us, we would probably close that out with like a warning letter if there was, if they had already turned over the records and everything, if we'd gotten compliance on it, and it wasn't continued for those lower level. It didn't rise to the level of a citation.
In the construct that you're developing, in the sort of arsenal, there will be warning letters, there will be citations and fines, and then we could go straight into discipline, which the one option would be you have reprovals and this admonishment thing, but admonishment is not discipline. So let's set that aside. You've got reprovals and they would be public. I think that's what you're advocating for, Kim. Basically, everything moving on down is public. ADP is an NA for us for right now.
And I think maybe it would be a little bit different than state bar where you are right now, but I think those public reprovals, similar to our term, that happens before NDC is filed are very useful, and they save a lot of additional time and energy.
Okay. So I emailed Danny while we've been on the phone, on the Zoom, to ask her. So here's what she said about private reprovals. They can be used anytime allowed by the standards. There we go with the standards again. Conflicts, performance, illegal fee commingling, negligent misappropriation, breach of confidentiality, UPL, frivolous litigation, etc. If they stip before charges are filed, they are private. If not, public. If they do catch a new case, then they become public as private discipline, as prior discipline. So I guess following Kim's line of thinking, I would say these should probably be public.
Which?
And we get rid of this category. It's just called a public reproval.
And the public reproval could be issued maybe before a notice of disciplinary charges or NDC, whatever, filing, or after. I think that might be an option that we want to put out there for this group. Does that make sense?
Mm-hmm.
The Med Board has something like that, doesn't it, Kim? Where
Yeah, that's that public letter of reprimand in 2233. And they're very helpful. If you know that the licensee is not somebody that it's not going to rise to the level of that person needing probation, then there's really no reason for you to go through the formal charges being filed and going through that. If it's like a first time for this individual, usually first time. And So we go through that. If they agree to it, the public letter of reprimand, it's still disciplined, still gets put on their record, still stays out there. People know that it went through. It is a really big benefit, at least for us, because then you don't have to spend the additional time to go through them filing everything.
But what is the incentive for the doctor? Like, the doctor doesn't care about using the medical board's resources. I see why we would want to, but is there any incentive to say, let's resolve this before an NDC is filed?
Yeah, because his charges for his defense are going to be cut in probably of 25% of the normal charge, because they would just have somebody really that would look at the public letter of reprimand and say, you know, the language looks okay, because they have to agree to the language and everything, and that would be it. As to where if you went through filing the charges, then you have discovery and you have you know, setting up the hearing and settlement conferences and all of that, where you're paying a defense attorney a lot of money.
Okay.
Kim, you said they have to agree. So they, meaning the doctor, I guess, right? So the public approval then is obviously in that situation a matter of settling the charges. But is it ever used simply as a decision by the board, whichever board it is, that we're going to do a public approval and we'll write the language, and this, you know, the doctor doesn't have to approve it. We're just deciding that.
No, because then we have not given them their due process rights. I mean, from our perspective, that's where we would stand.
Oh.
I guess, because then their only avenue then at that point would be to appeal it to, I don't even know who they'd appeal, maybe to an ALJ or to a superior court. So that's why it has to be by agreement to afford them due process.
Well, the
If
citation.
they say no, we file an accusation and go to hearing.
Yeah. 2233 is entitled Public Reprimand, and it says the board may, by stipulation or settlement with the affected physician, issue a public letter of reprimand after it has conducted an investigation or inspection, rather than filing or prosecuting a formal accusation. The public letter of reprimand may include a requirement for specified training or education.
Well,
The physician has to indicate agreement or non-agreement in writing within 30 days of formal notification by the board of its intention to issue the letter.
who has to agree?
The physician.
Yeah, so they could
They can disagree, and then the board will just file an accusation
Oh,
and take it to hearing.
apparently it can't work like the citation and fine. The board just makes a decision to issue a citation and fine, and then if the doctor doesn't appeal, it's final. This public approval couldn't, well, in theory it could work that way, couldn't it? But it doesn't, right?
Yeah, you'd probably have to have statute for it, because again, I think there's that whole due process issue. I guess it depends on where you'd authorize them to appeal it to. It'd have to have something written in there.
Yeah. Okay, got it.
Yeah.
So is this looking right here? NA for private reproval, public reproval could be issued before an NDC is filed or after. Okay. NA on ADP for right now, probation.
Do we want to put any time limit on the public reproval? Are we coming back to that?
No, we're coming back.
Okay, all right.
I'm trying to take us through the first cut.
Perfect.
Okay. Probation public, right? Suspension
Yes.
public,
Yep.
debarment public.
Yes.
All right.
Yeah.
We will have to come back to this admonishment at some point. So let me just keep inserting columns. I think I'm going to take it out of track changes because it's looking weird. Okay.
Right, as this stands now, we've got nothing that constitutes discipline that is public. That is private, sorry.
Right.
I wish I was doing this in Excel.
Oh, there, by the way, for at the end of our meeting, there's something in the news today that we should consider.
What? That's
What should I say? All right, I'm just kidding. I don't want to waste people's time. Well, it's Navalny.
oh,
Oh, yeah.
yeah.
He's
What
put
is
on
it?
probation. Part of the probation is he can't leave the country. He's got to report to his probation officer or something in Russia. Then they poison him and he has to go to Germany for the treatment. And then it's a probation violation because he's outside of Russia. We should outlaw that in our
How
state.
is that relevant, Ira?
That's something we should make sure is excluded from
happen.
our system.
Okay. Do that.
Yeah. If we poison you, that's a probation violation.
Oh, if the state bar poisons you.
Yeah.
Yeah, okay. We got bigger problems. All right, I read all up on that, the New York Times Sunday paper. Crazy situation over there. Okay, so now, forgive my terrible formatting. So here we have for question 1, private or public. Now we have question 2. Do you want to go for duration or do you want to go for on website or not?
Well, there's 2 durations. There's duration as a record and duration on the website.
Yeah, which one do you want to do?
Oh, yeah, I don't care.
So like private, the first one we get to is citation and fine. Should it be what I call affirmative or responsive? Put on the website or only upon request?
All right, so that's our question.
Website.
So you say website. Julie, Ira?
Website.
Yeah, me too.
All right. Notice of disciplinary charges website. I think we're going to go website all the way down probably, right?
Yeah.
Okay. So I can do that. So now let's talk about first there's the issue of could it transition from the website to still being public, but public upon request? And then the issue of does at some point it go away altogether? Or I guess at some point, does it become private? I don't.
Yeah, and then does it go away altogether? So we got 3 more questions.
So citations and fines, it's available. And I forgot what you said. It's available on the website for 3 years.
Yes,
Does it go, and then it's expunged?
it's expunged at that point, yeah.
Meaning it's pulled off the website and also it's just completely purged as if it never existed.
Yes,
So if someone does a Public Records Act request, they won't get anything.
no,
And you can't use it in subsequent discipline.
it's not discipline, so we wouldn't use it even as aggravation, no, after that time.
Why don't we put up here on Leah, over on the left, not
Mhm.
discipline, under the word citation and fine, right? Not discipline. So we remember.
I'm kind of struggling because I feel like if somebody keeps getting these, you should be able to do something about it. But then immediately I go to, well, if it keeps happening, then the prosecutor's office needs to do something different.
So it's in our database, not the actual citation itself, but the fact that this individual had a complaint that was a citation would be in our database. So we would know.
Oh, so it doesn't completely disappear.
It does not completely disappear.
Another category here.
Oh,
Don't do that. No, don't do that.
this is like the admonishment. You're bringing this in out of nowhere, Kim.
I know. I just realized that. No, we would still know about it. It's just the document itself gets purged.
Oh, yeah.
But there's some
Purge
notation.
the document, purge substance, but not incidents. The fact that it happened is not purged. The substance of what happened is purged. Is that what you mean, Kim?
Yeah, that's going to be a hard one to, I don't know if I'd even put that in there, Leah.
Okay, well, I just put it at the bottom. So let's just stick with what we have. Citation and fine. We agree it's going to be on the website. Do you think at some point it should come off the website?
I do. It's a tool to use, but not indefinite, because they're minor.
Yeah, I agree.
Julie?
Yes.
Julie, you sound exasperated by it.
Well, I'm reading the statute that describes citations and fines, and it doesn't say anywhere that this is not discipline. So I
Oh,
how that evolved, but
You know what? I think for medical board particularly, because the things that are discipline are in, I think aren't they in like another section, 2227 or something like that, or?
yeah. Yeah, 2227, disciplinary action, public record.
Yeah, I think that's where we get the term.
And citations are not in there, but the public reprimand is.
Yeah. It's kind of different, but yeah. And I don't think anybody, even though it might not be in that 125.9 or 0.3, the citation, I don't think anybody counts them as discipline. Where that comes from, I don't know though.
I've heard that for a million years. I
Yeah.
just wonder where it came from. I don't know. Maybe it's in legislative history or something.
Could be. So I think it should, we used to do them for 5 years, but I don't,
Yeah.
citations are such a low, and I hate to say this, but they're a lower minor technical violation that I think 3 years is a good time. I didn't like it at first, but after it happened, I'm not opposed to the 3 years. And at least that way, when you sell this program, we can explain that, it's similar to what physicians do, if there was any question as to where our reasoning came in.
Is that in a regulation, Kim?
The 3 years?
Yeah.
No, it's in 2027.
Oh, okay.
Okay. Ira, how are you feeling about 3 years? What?
Yes.
Okay.
Agree.
Julie?
Yes.
I know you're reading. Okay. And then what happens after 3 years? Purge altogether. Purge substance, but not incidents. Or just keep it, but only subject to a request.
Maybe you keep it, because I'm not sure if we have you want to go through the legal authority to not have it.
The legal authority to not have it.
I guess we're writing the authority, so we could say whatever right here, right?
Yeah.
I say it should, my opinion right now, it should not even be subject to request, but it shouldn't disappear as a record so that the prosecutors can use it in the court.
Are we still talking about citations and fines?
Yeah.
So website for 3 years, then Ira would say, then transitions to private. And Julie, what are your thoughts on that?
I'm okay with that.
Okay. And then let's just keep going, and then we'll get to, does it ever get destroyed? Okay, but we've made progress. Notice of disciplinary charges.
So we're just to give you some context with medical board, that notice of disciplinary charges itself, and this is not for all boards, so other boards just keep that accusation up there with the discipline indefinitely, but medical board was written a little bit weird when they did add them back on to where it's part of either your proposed decision or it's part of your, or the final decision or part of your stipulation. So like on your stipulation, it's an attachment, it's Exhibit A is your accusation. And it's written to where the underlying document of whatever the discipline is part of that record. So we kind of take it down as an accusation. I don't know that that's good or not, but I think that the notice of disciplinary charges should be up there in the same amount of time as whatever your discipline is.
Okay, and Linda, correct me, I don't know if Linda's there, but I think our discipline is there forever.
Well, what if the charges are not sustained? Doesn't it disappear?
Oh yeah, that's a good point, yeah.
Right, I'm talking about
Well,
where.
What do you mean if the charge? I think if there's an NDC filed, I think that stays on forever.
Really? Even if the person is acquitted?
Well, it shouldn't.
Right.
Maybe not.
Let me ask Danny, since I've been emailing with her.
So for the medical board, if it's withdrawn, which is a little bit different, and we withdraw for two reasons. One, the individual passes away, or two, we identify new additional evidence that we can no longer prove our charges and we'll withdraw it. So those are the two reasons. If it's withdrawn, it comes immediately off the website and then it gets purged after a year. If it goes to hearing and an ALJ dismisses it, where we weren't able to prove our case, it comes off the website, but that disciplinary document is available indefinitely. So that decision of dismissal, if you write in or ask for it upon request.
You mean just the decision is available, or the whole, or everything about the charges is available?
The whole thing. Yeah, you could get a copy of the accusation or just the proposed or the final decision.
And so a member of the public, in other words, can get all that stuff.
Yeah.
Doesn't seem right. Right, that doesn't seem right somehow. It's true in the criminal system, of course, but still.
Well, your dismissal document, I mean, it's going to have a lot of that, at least for us. I'm not sure how your court writes those, Leah, on the state bar side, but it's going to have all of the charges anyway in that final decision. It's going to have them listed and listed out what the individual allegedly did, but then it's going to also go through that process of saying, you know, we heard it though, and at the end, we didn't find that there was any, it wasn't sustained. That's right, yeah.
Okay. Let's start with an NDC where charges have been sustained.
Say that again?
An NDC where the charges were sustained. And I want to be careful saying that, because sometimes the charge, whatever's been sustained, is not necessarily everything that's in the NDC, right? It can differ.
Right. But
So,
that's all explained in the decision.
yeah, let's say an NDC that results in discipline.
Yeah.
Okay, so Kim, you're suggesting the NDC stays up as long as the discipline stays up, meaning on the website?
Yes.
But I think, and Linda, correct me if I'm wrong, discipline now stays on an attorney's record forever. Like if you've been suspended, that doesn't come off in 10 years or 15 years. It's just on there.
So I guess the only one that's different for like us is the public reproval. What you guys would have as a public reproval. For us, that comes off in 10 years. If we're going to go forward where we keep everything indefinitely on the record of your discipline, then we don't even need to talk about how long they stay on there, you know. Does that make sense?
Yes.
Okay.
It's my personal perspective that it is kind of weird that it never comes off. Like 20 years later, you still have this thing on your record.
Mhm.
It feels a little weird, but anyway.
I think it depends on the level. I mean, The public reprimand ones I can see coming off because again, we didn't think anything needed to change with their practice, kind of along Linda's, what she was explaining, why it doesn't have to go to the Supreme Court. It's because it's not impacting their license per se. It's just a public reprimand. I think that's kind of the discussion amongst everybody as to why that 10 years, they put that up there. As to where if you get put on probation, that's really serious to me. And that's why I think for us, we wanted it out there indefinitely. Again, medical board way back when in 2003, the law changed and said it was 10 years, and then we got it overturned in 2015 to go back to keeping them out there indefinitely.
Okay, I read Julie. So Kim, you think, other than perhaps for the public reproval, staying up forever is fine?
Yeah, as long as we decide that that's what the discipline's going to be, yeah.
Well, to me, I need to make it more complicated, but to me, it should be forever for most discipline, but not for some that isn't as serious. And that should be 10 years or something, say 10 years.
Okay, I don't know that that's different than Kim's. Because I think, Kim, you're saying it aligns with the public duration of the underlying discipline.
Yes.
And Ira, I think what you're saying is some discipline won't be public forever.
Yeah.
Yeah, so I think that's the same point.
Yeah, I thought so. Yeah.
Julie, what do you think about that?
I'm lost. I just remember over at the Med Board, originally there was a law that said everything that goes up on the Med Board's website has to come down after 10 years. And in fact, that 10 years from when that law went into effect, the board was having to take down all these horrendous disciplinary decisions. And we fought like hell, and we had to give up some public disclosure to make those disciplines be disclosed on the website indefinitely. That's the law change we got. I don't remember when, Kim.
2015. I think it was part of our sunset, came out of our.
Yeah.
Yeah.
I just remember that we even had to give up some stuff, like the medical board, unlike the bar, discloses medical malpractice settlements if they're over a certain amount and within a certain time period. It's never been particularly effective, but we had to kind of give that up in order to get indefinite publication posting of actual disciplines taken or stipulated to.
Yeah, it dropped from 10 years to 5 years for the malpractice. Yeah,
it's that no settlements will ever be disclosed on the Med Board's website now. But
they do have some.
Really?
Yeah.
Okay, so Julie, it sounds like you believe the NDC, we're talking about ones that result in some kind of discipline.
Yes.
They should stay up forever.
Yes.
And Ira and Kim, it's a suggestion that they stay up as long as the discipline stays up. So let's move on and let's talk about how long the discipline is going to stay up.
Leah, before we move on for that, would you make a note there that we're talking about those disciplinary charges that result in discipline?
Mm-hmm. And then we have to talk about ones that don't.
Yeah.
All right. Okay. So let's go to the public reproval. Because this might be one where it's not going to be in perpetuity.
Right.
So at the medical board, 10 years.
Yes.
Yeah.
On the website.
Mm-hmm. Do you want to follow the medical board's process?
Yes,
10 years on the website. So if we say 10 years, and then after the 10 years, it transitions to public on request at the medical board, Kim?
Yes, indefinitely.
Okay, and is that what you, Ira, and,
Yeah, that's fine.
yes.
okay, so then let's think about an NDCs filed on a public reproval. So then if we use this scenario here, stays up as long as the discipline stays up, that NDC would be up for 10 years. And then it would move to public upon request indefinitely.
Mm-hmm.
Yeah.
You're talking about a public reproval that's issued after the filing of the NDC?
Yeah, so I'm trying to work with this scenario where the NDC stays up as long as the discipline stays up.
I see.
But Julie, that's slightly different than what you were suggesting, but it does align with what Julie and Kim were talking about.
It doesn't, here's the thing for me, it doesn't make sense to have a NDC out there if there's no outcome for it to me. So if we're going to say like the discipline of the public reproval comes off after 10 years, when people go look at that NDC, then they're going to be like, well, why is this out there? Although I guess it does alert the public that there is something there.
So Julie, I think yours kind of, do you still want to have us consider the NDC being up there in perpetuity, even if the public reproval comes down after 10 years?
I don't know.
Okay, so we'll come back.
Over at the Med Board, the accusation, which is what they call an NDC, is filed, and it's just sitting there. Once there's a decision, the accusation becomes like an exhibit to the decision. So it's still there on the website, but it's hooked onto the decision. I don't know that it's necessarily categorized as a separate document anymore, if that makes any sense.
Well, is it public the moment it's filed?
Yes.
You mean the
accusation?
Yes, it is. And it sits there as its own separate document until there's a decision made on that accusation. And then it is attached to the decision. So you have to read the decision, and then the decision instructs you to look at Exhibit A for the accusation, the actual findings and conclusions of the judge that have been approved by the board.
I like that.
Linda, I don't know, you know this better than I. Like, I'm just trying to understand how that's different than the way we do it. Our NDCs are posted completely separately, independently of any decision.
The NDC is posted as soon as it's filed.
So maybe the question I have then, like going to what Greg was talking about for the letters of admonishment. So the NDC is filed, goes to the Supreme Court. They issue a letter of admonishment that's not public. What does that look like on a person's file?
Well, actually, the NDC goes to the state bar court, not to the Supreme.
Oh, sorry, state bar court. Yeah, sorry. So the state bar court issues a letter of admonishment. What is on the person's record? What does it look like?
And I think that changed recently because there was a point when it was all right. All the documents were right on the state bar member profile. And then it moved to being on the state bar court website if you wanted to look at the documents. And I don't know if it's, and that was a little bit cumbersome, but I think it's back, they're back now.
They're linked from the member profile. But I think that's a little bit different of a question. We didn't even have admonishment on our chart, and I don't feel like I knew that that happened. So I don't know what it looks like on a member's profile. We have to find someone who
is
had
there-
an
I don't
admonishment.
think that they're published on the, I don't think they're considered, admonishment is considered discipline.
No, I
At
don't
the
think
end,
so.
but we'd want to find somebody who had one to see what their profile looks like, because the NDC itself is public. Right?
Yeah, but the thing about admonishment, I think that's more akin to like a warning letter, because admonishment is not any form of discipline. The lowest level of discipline is the reproval.
Yeah, but Greg is saying the State Bar Court issues these letters, and that's after an NDC has been filed.
Okay.
So I don't know about the admonishment, Kim. We have to get more information.
Okay, well, even, how about so you have a private reproval that happens after an NDC. Can you have a private reproval that happens after an NDC?
Yeah.
Yes.
Okay, so how does that work? So the NDC is posted out there and then the private reproval is not there. So how do you know what the outcome of that NDC is?
Where's my, oh, yeah. That's what I was referring to earlier, why the private reproval is so curious to me, because I think after a NDC has been filed, even though it's called a private reproval, it is part of the attorney's official State Bar membership records. It won't be, but it says it won't be disclosed by in response to public inquiry. So that's a good question. I don't know if the NDC would just be on the member's profile page and then no resolution.
Yeah,
provided?
that's what Danny wrote in her email to me.
No resolutions provided.
Yeah. So it just
Just
says
stays there?
charges remain public and stay there, and then nothing else is there. That seems really unsatisfactory.
Really weird.
So I think we need to, my to-do is I'm going to try to get the names of a couple instances where there's been an admonishment, there's been a private reproval. We can actually just look at the member profile and see. Obviously, we're not going to do that in a public meeting, but we'll be able to take a look and see what's going on with those. So I think just to get us back to where we are, public reproval, the options are in the NDC stays up for as long as the public reproval stays up, 10 years. That both the NDC and the reproval itself come down, but they both remain public upon request. That's one option. Another option is the NDC stays up in perpetuity, but the reproval itself comes down after 10 years. Which is this scenario that we're talking about, perhaps this exists now for private reprovals post NDC in the attorney world, and seems kind of weird that you'd have like a hanging Chad NDC.
Sounds like a good topic for the ad hoc commission on the discipline system that's starting.
So Leah, can we hold on that one until we know kind of what it looks like?
Okay. All right.
I mean, there is some benefit for having that NDC out there, because one complaint we get is, if your doctor had a public reprimand at the medical board and it's been past 10 years, how would the public ever know to inquire to get a copy of it?
Mm-hmm.
So.
Okay, so the rest of these, probation, suspension, disbarment. Do you feel these should be on the website forever?
So is suspension for you all only issued, and I think maybe we've touched on this before, is suspension only issued as part of discipline? It
Yes.
can't be, do you have like an interim
Oh,
type of suspension too? Because that's why I put in there when I was putting this in about the difference between a suspension if it's part of an interim suspension order, it actually comes off. But if it is part of a, probation and suspension, then it stays out there indefinitely.
Right, and we do have interim suspensions and restriction that are regulatory and not disciplinary.
Yeah.
And in fact, based on my work with the ADR, actually it all falls under probation, and you have probations with actual suspension and probations with stayed suspension. So I think maybe suspension should go under this category of probation, and it's not really a separate category. Suspension is a condition of probation.
But Linda, what about those, I think, and maybe Greg, it's the cases where there's like a severe mental health issue. And I thought there was the ability for OCTC to immediately put someone on an interim suspension status.
That's right. And I think also a process of taking jurisdiction over their practice if necessary.
Mm-hmm.
There's also interim suspensions following certain criminal convictions if it's severe enough. And we also have in the administrative suspension category, people that fail to pay their fees or did not comply with MCLE. There are administrative suspensions tied to those as well as an expungement procedure for people to expunge that from their record.
But back to your question, Kim, I just don't know, like, does an NDC have to be filed in order for OCTC to take advantage of these various interim suspension options, like a criminal conviction, based on a criminal conviction, based on a mental health issue? I think the answer is no.
Right. Yeah, with the criminal conviction, OCTC really doesn't do anything other than transmit the record of the conviction directly to the Supreme Court.
No, but what Greg is saying is they do have the ability to suspend.
Right. But I'm saying that I don't believe that involves an NDC. I'm agreeing with you.
I think it's referred a criminal conviction referral. Usually goes to the review department, and the review department will make a determination, I think, whether or not in that instance, whether or not there should be an interim suspension.
An interim suspension by the court. So it sounds like there are interim suspensions, Kim.
Okay. Because I think to Linda's point, I would agree, even for us, suspension is usually part of you either do, all of ours are usually revoked stayed suspension or revoked stayed probation, with a term of suspension. And I guess you could have a stayed suspension too as part of the probation. So they're part of it, but then there's another category that we would be missing, and that is the suspensions that happen under these interim. So we have like an interim suspension order. We have a PC 23 Penal Code Section 23, which I think is what Greg's talking about, where an individual gets convicted and you can go in and get a restriction on practice or a TRO, those kind of things. So for us, those are suspended, and as long as it's in play, it's on the website. So during the time it is in effect, it's on the website, but it comes off after, when it's no longer in play. Does that make sense? So like we're investigating, and we have a doctor that is, we go in and request the interim suspension order, and they issue a suspension while we're still investigating and while we're still going through the discipline process. It stays out there as long as they're suspended. And usually what happens is then we file an accusation or we take action. And when that happens, then that, when it's final, that comes off the record. But it's still something that's indefinitely public.
Kim, when there's a suspension for disciplinary reasons anyway, is there always probation?
No, a judge could issue up to a 1-year suspension as part of discipline. You don't see it. I probably in my whole career over there, I saw it maybe once where just a suspension was issued without some type of probation with it.
Does anybody know about that for the state bar? Is suspension always accompanied by probation? When the suspension is for disciplinary reasons?
I believe so. I believe the suspension is a condition of probation if it's a disciplinary matter.
I've never seen an attorney placed on a suspension without there being a probation with conditions for probation that need to be satisfied. Usually there's, as Linda said, there's usually a term of a state suspension that's longer, and then they're placed on probation. One of the conditions is that they serve an actual suspension, which is much shorter, and then also fulfill a number of other conditions under, I think it's Rule of Court, Rule 9.20, which involves notifying clients, notifying courts where you have pending matters, making sure you're making reports to the probation department on a periodic basis, and failure to comply with those conditions may result in the state suspension becoming unstayed, and you end up serving a longer suspension. And there may be conditions that like, for instance, in some circumstances, the lawyer may be required to provide restitution to a client that they've taken money from, and until they make that restitution, they remain on suspended status. I don't know if that answers
As
it.
long as it occurred to me to change the term, the wording here, where it says suspensions pursuant to probation to suspensions pursuant to discipline. And now I'm hearing that it's nearly always probation, but maybe we wouldn't always want it to be with probation.
Okay, let's go back to Kim's original point. There does seem to be kind of a logic to the interim suspension being public only for the pendency of the interim suspension, right? Just for fairness, because like if you were suspended, but then the issue was resolved and there was a determination that you didn't actually need to be suspended, then that seems like it should come down.
What happens more frequently is that there is that, and the medical board, and I think the bar too, under 6007C, can swoop in ex parte without even notifying the licensee, seeking an interim suspension. But there's provisions too for non-ex parte swooping. What happens more frequently is that the judge will grant an ISO, interim suspension order, and then the licensee will stipulate to extend, and that interim suspension order has a time frame within which the medical board has to file the accusation. So at that point, the accusation goes on the website and probably the ISO order comes down.
Okay. Is that a process that you think should be replicated here? My 2 cents is it sounds like it should.
I don't see why it shouldn't.
So it's public for the duration of the interim suspension. And if an NDC gets filed, that becomes public, but the interim suspension itself is public for the duration of the interim suspension.
Yeah. And you might have to label it as whatever other kind of suspensions. I don't know, Greg, is it a PC-23 suspension that you're talking about on the criminal side? Is that what you guys use?
I'm sorry, I'm not sure what is PC-23 refer to? Is that
Penal Code 23, it says if a licensee has been arrested and incarcerated, in the medical board's case, the deputy attorney general representing the board can appear at that person's bail hearing and ask that superior court judge to impose restrictions on the license if that person is granted bail.
That's not our process.
Okay.
No.
But you do have some type of suspension for a criminal conviction, and that would still be referred to as an interim suspension.
Yes.
Okay, perfect. Then we've covered it all, I think, for suspension. And then if that's the case, you might want to make sure we know the difference between the two. Yeah.
You mean between which two? Discipline and probation?
Yeah, I think because we're kind of talking about these things over here on the left, your probation, suspension, those are kind of like a document in and of itself, right? I don't know that you're going to have a document that is a suspension document outside of that interim suspension, are you? Because isn't that suspension going to be part of your probation document?
For the non-interim cases?
Yeah.
I think so. I think we need to get more clarity on
Okay,
nexus
perfect.
between discipline, probation and suspensions. Like, is everybody who's suspended on probation?
Got it.
Mhm. But let's say we resolve that. The policy decision is suspensions pursuant to discipline are going to be public forever.
Yes.
Yes.
And on the website. Okay. And the same, and disbarment
Yes.
forever.
Yes.
Okay. So, okay, so we've got 10 minutes. What else do we need to decide? Citations and fines, 3 years, then transition to private and available forever.
Patients and
Well,
You mean available pursuant to a Public Records Act request?
No, they're transitioning to private, so that means not available pursuant to a Public Records Act request, but not destroyed, which would mean it could be used. This is the rules that we're creating, I guess. It could be used as aggravation, essentially, even though it's not discipline. And that would be the point of keeping it private, or I guess you keep it private so that, you know, the OCTC prosecutor, they can see it. It's 10 years old, but I'm seeing that there were 5 similar incidences 10 years ago. So I'm going to take that into account.
yeah, I agree with this, the way it's stated here.
Kim or Julie?
I agree with it because again, those are the, technical minor ones. And I think after the 3 years, I don't think it should be available.
Okay, but not destroyed.
That's a hard one with that Public Records Act, what Julie's talking about. You have a document that's public, I mean, and maybe that's probably why we purge ours, is because then you don't, it can't be gotten through a Public Records Act request.
Julie, any thoughts on this one?
No, I'm not sure what's on the table here. We're still talking about citations and fines and whether they should be purged after 3 years.
Yeah, or simply transition to private status, meaning not available upon request, but available for the use essentially of OCTC or the prosecutorial, the discipline system.
I like the latter,
Private,
Private.
transition to private.
but available for use if by the prosecutor in appropriate cases.
Okay, on the NDC issue, we need to get examples from admonitions and what's the other one? Private reprovals post NDC filing to see what that looks like now.
Mhm.
Public reproval 10 years and then public on request indefinitely. Here, just getting clarification on whether all suspensions, all disciplinary suspensions equate with being on probation. But I think we've resolved here, nothing's getting purged. So basically nothing is getting purged in our world, right?
So I have 2 things that I was looking at another document, 2 things just real quick to throw out there. And that is a citation and fine could also be withdrawn or dismissed by, I'm assuming if we appeal those, if the individual can appeal those to the state bar. So maybe if it's withdrawn or dismissed, it would also come off the website. So we probably need to put that as a caveat if everybody agrees on that.
Yeah.
Yeah, I agree.
And that would be the same thing for your NDC too, I think, Leah.
For all NDCs. Which, Linda, you're saying doesn't happen now. I don't know if she's there.
I'm sorry, what did you ask?
Just if NDCs are taken down where they are withdrawn or the case is dismissed by state bar court.
As far as I know, they're not withdrawn, and isn't that what Danny confirmed? Isn't that what you said?
She doesn't know what happens with the website. So that's just.
I don't know either what happens with the website, but I would
Okay.
think if it was something that was filed in state bar court, that's going to be a record that's available, right? It's just a matter of whether it's going to stay, the link is going to stay on their profile on the state bar page.
Yeah. Okay, so I think we have a little bit more work to do, but we're almost there.
It'll be interesting to know if they, I would guess that if NDCs were not taken down for cases in which the charges were either dropped or the person was cleared of the charges, we would be hearing from those lawyers
Yeah.
in the court asking them to take down, and I don't recall seeing any petition. We do get, requests to expunge records in other circumstances, but I would imagine that they are coming down, but it would be good to know to confirm them.
Okay, all right.
Question on your chart here, under the NDC line,
Mm-hmm,
where on the doctor's column,
mm-hmm.
it's public on the website unless withdrawn or dismissed. If withdrawn, public upon request for 1 year. And if dismissed, public upon request indefinitely. Is that right?
Yeah,
But it comes off the website if it's dismissed, doesn't it?
yeah, it comes off the website for either or. It comes off the website, but it's, so that's why it says public on the website unless withdrawn or dismissed. So it comes off the website, either
Okay.
of those two things.
Okay,
But then if it's withdrawn, you can get it for 1 year, but if it's dismissed, you can get it indefinitely.
okay, I get it now.
What is the rationale for that distinction?
Yeah, I was going to ask the same thing.
I wish I knew.
You were in charge, Kim.
I know, those laws were there before me though, I think. I'm assuming the withdrawn is that the allegations, I mean, we ourselves actually said, we cannot prove this, there's nothing there. Oh, I know what it is. Sorry, all of a sudden I remember. Because the dismissal, so the withdrawal is just something that the executive director signs. And it's a withdrawal of the accusation. The dismissal document is an administrative law judge document, and their documents are public indefinitely. It's a public document. That's what the difference is.
We don't have to worry about it. We're not using ALJ.
Right. But that's why I think there's a government code section. It's a different section of law. I think it's on that sheet that the one that's the medical board. If you go out and look at that, that's what it is. Under the government code section, their documents are public always.
Okay. All right, so we have some work to do on this. We have, remind me, please, of your decision on who is going to hear the appeals, the panel or the board? Or
I don't
have
think
you
we
not-
made that decision yet.
And you're not making it until you know who's on the board. Is that right?
That's my understanding.
Okay.
We don't even know how many people are going to be on the board and who they are and who's choosing them.
Okay, so we're not going to have a recommendation on that. And then I think our last issue that we haven't touched on is mandatory fee arbitration. So I'd like to recommend that at our next meeting, we come back to public records, finalize this with the information that I'm able to bring back. And then we hear from the folks that run the mandatory fee arbitration program so that you can make a recommendation, develop one as to whether or not that avenue should be available to paraprofessionals and their clients. And I think that's our last issue.
Are any of the other subcommittees working on fee arbitration? It's a little tangential to what we're doing, I think. I don't mind doing it. But.
I don't think it's tangential because it is, well, I guess it's an alternative resolution for fee disputes. And fee disputes are going to be one of the primary reasons that folks file complaints.
Yeah. Okay.
So I think it's simply to say, I mean, I kind of think it's a no-brainer that we'll say this avenue should be available. And the recommendation would be that the state bar figure out how to make that happen.
Well,
yeah.
Not just available. Oh, well, anyway, that we adopt essentially the same thing as mandatory fee arbitration.
Yeah.
For lawyers. I agree with that. Maybe we don't need to talk about it.
I think it's a good thing too, but I would like to know more about what it does, though. Okay. Leah, do we also have the unlicensed? I can't remember what we're doing about that.
We do. We need to, I'm going to schedule a joint meeting. It doesn't need to be done for the February meeting. We're going to have a joint convening of this subcommittee and the regulation subcommittee, and then open to whoever else wants to attend to hear from the folks that you heard from in OCTC, as well as the LA, I think that was the city attorney's office or the DA's office.
It was the DA's office.
And give them some time to prepare kind of their wish list or what they think needs to happen to beef up the infrastructure and capacity to prosecute UPL. And I think then there'll be a set of related recommendations that coming in the final working group report, understanding that it's somewhat outside of the purview of the working group. But that's fine.
Leah, would you email us this document?
I will, but it looks, it's embarrassing. I'm going to get Linda's help to make it look better, but I will.
All right.
Yeah. Okay. All right, everyone. Thank you.
Thank you.
Thank you.
Bye.
Bye.